Good morning. Thanks, Dean, for initiating this event. And it's my great honor and privilege to moderate this panel of distinguished speakers, consisting of a government official in charge of IP matters, and also prominent IP scholars from the top law schools in Hong Kong and in Mainland China, and also practitioners who are very experienced in IP practice in Great Bay Area. And they are going to offer their insight and foresight about the harmonization of IP regimes in Great Bay Area, and also the associated challenges. Okay, without further ado, I would like to introduce the first speaker of this panel. It's Professor Cui Guobing. And our panel will be very different from the first panel. I'll adopt the more traditional format that allows speakers to speak about 14 to 15 minutes. And then we'll have about 15 to 20 minutes discussion at the end. Okay, so I'll also be very brief in introducing all the speakers. And you all have their bios, so you can see the details of their background. The first speaker, Professor Cui Guobing, who is a professor of law, also the director of the Center for Intellectual Property at Tsinghua University Law School. And his topic will be on the harmonization of arbitral award on patentability between HKSAR and Mainland. Let's welcome Professor Cui.
Okay. Thank you, Professor Li, for inviting me to be part of this great event. Personally, I'm very happy to see quite a lot of old friends here. Today, I would talk a little bit about a relatively technical issue about the harmonization of the Hong Kong and Mainland China's law on the arbitration of patentability issue. Okay, the first one, we talk about the general introduction to the background, what means the arbitrability of patent validity issue. In Mainland China, we have an arbitration law, the Article 3, defines the scope of the of the issues that could be referable for arbitration. Article 3 say the arbitration law provides the party may not arbitrate issues that are not to be determined by administrative bodies. Here's the article saying the following dispute may not be arbitrated, including the two items. The first one is marital, adoption, guardianship. All these kind of things are relevant to personality interests. So the law made it clear this kind of personality interests or personality rights could not be subject to arbitration. The second one is about the administrative dispute that should be handled by administrative bodies as prescribed by law. So here, Article 3 of the Chinese arbitration laws require if the issue should be determined by the administrative agency, and then this issue should not be arbitrated. The law does not spell out the issue of arbitrability of patent or IP dispute, but it's widely believed that the validity of patent should be determined by the re-examination and the invalidated department of the Chinese Patent Office, here the China National IP Agency. So if we believe it's kind of things should be determined by the agency, and then according to this article, it's pretty clear this kind of dispute on patent validity should not be arbitrated under the Chinese mainland law. And if you do ignore this kind of rule and do this kind of arbitration, and then this Article 35(8) may be applied. They say if the matters decided in a word exceeded the scope of arbitration, and then the court could refuse to honor the decision, or could one party could apply for setting aside the arbitration award. That's the Chinese law. And the second, now we move to second one, have a very brief introduction to the Hong Kong law. That's why I choose this one. According to my research, I only know there's a significant difference between Chinese IP law and the Hong Kong practice. So I choose this one. According to the Hong Kong law, arbitration ordinance, I think it was, I think the recent amendment is in 2018. The arbitration ordinance allows a dispute on patentability to be arbitrated. Here's the section 103C. It clearly say a dispute over IP, including validity and ownership and other issue, make this kind of IPR dispute attributable. And also here, Article 103D emphasize even the foreign law or the Hong Kong law does not make it clear whether IP dispute on validity is arbitrable or not. Even there's no keep silent on this, that does not make this kind of dispute inattributable under this kind of ordinance. So according to this kind of rule, even foreign country's law does not say anything about the attributability of the dispute. I guess the ordinance will view this kind of dispute as attributable under the Hong Kong law. And interesting, the Hong Kong arbitration ordinance also incorporate the Article 34 of the model law, the unilateral model law. According to this kind of model law, if an agreement is according to the under the foreign law is not arbitrable, and then this kind of agreement to arbitrate maybe should be viewed as invalid. If the agreement is invalid, and then the parties one of the party could seek for setting aside the arbitral award. I think that means the Hong Kong law also allow the party to challenge this kind of reward, right? If the agreement is to be viewed as a invalid one under the foreign law. So the Hong Kong law basically allows the party to arbitrate this kind of validity issue. But if the agreement is against the foreign law, maybe according to this rule, the parties could seeking for judicial court decision to set aside this kind of decision. That's the difference between Chinese law and the Hong Kong law. Chinese law, the mainland Chinese law does not allow this kind of arbitration, but the Hong Kong law does allow. So, and merge to the third one is a very brief introduction to other countries' practice. Now, I think many common law countries allow this kind of attribution, including United States, UK, Canada, Australia, Singapore, and also some, I think, civil law countries like Swiss, Belgium, and France allow this kind of attribution. That's the first one is a background on the attributability of patentability issue surround this world. Here, we mainly focus on the difference between the mainland law and the Hong Kong law. The second key issue is attributability and public interest. Under the Chinese law, why we treat the validity dispute as could not be arbitrated? I think the theory is pretty simple. Say, according to the Chinese law, once the decision has been made by the government, here the decision to grant a patent has been made by a government agency, and then all the parties, including court or private parties, should respect the court, the government decision, unless the decision has been invalidated through a legal process. Here, the legal procedure to invalidate the patent is very clear, right? You need to seek to file an administrative appeal to the patent office, and then the patent office will determine whether the patent should be invalid or not. Only when the government agency itself invalidates its own decision, and then the whole society could ignore the patent, right? If before a patent office to do so, everyone should respect the government decision. That's so-called the respect to the authority of the government agency. That's the legal theory underlying this kind of rule. But actually, this kind of rule is a very technical one, right? Why we should respect the court, the government authority? That has another types of explanation. For example, if we say the arbitral award is only binding to the parties, so the patent is still there, right? So we don't directly arbitral award does not directly invalid patent. They only bound the parties. So if you accept this kind of explanation, you could easily circumvent this kind of principle, right? We should under which we should respect the government authority. So the key issue is not whether the government agency's authority should be respected or not. It's easily to work around, right? The real problem is whether there's a public interest required for us to respect patent, right? To avoid this kind of arbitration on patent validity issue. Here, I try to argue that that really has a public interest concern. Here, I use U.S. Supreme Court case as an example to show the public interests underlying this kind of dispute. Here's a very famous one, the Lear versus Adkins case. It's about license estoppel, whether in a license agreement, the patent owner could restrict the license freedom or right to challenge the validity of the patent. Before this Supreme Court case in the United States, license is stopped from doing so because according to this kind of theory, say a license should not be permitted to enjoy the benefit offered by the agreement, while simultaneously urging that patent which forms the basis of agreement is void. I think that the logic is pretty clear, right? On one hand, you probably rely on the license to get some benefit. On the other hand, the license might want to go to the court, challenge the validity of the court. So they don't want to the licensee to benefit from these two perspectives. So that's the so-called license estoppel doctrine. But in 1970s, 1969, the Supreme Court overruled this kind of license estoppel doctrine, say the license may often be the only individual with enough economic incentive to challenge the patentability of an inventor's discovery. If the licensee are muzzled, the public may continually be required to pay tribute to would-be monopolist without need for or justification. I think the doctrine is pretty simple. Say, if we honor this agreement, which prevent licensee from challenging the validity, and then probably no one else want to challenge the patent, right? So the public don't know that the weakness of this kind of patent. So they probably keep paying this kind of royalty rate to the patent owner. So it's this kind of rule will harm the public interest. So the court are now ignore this kind of agreement on the non-challenge the patent validity challenge articles. So allow the patent licensee to challenge the patentability. So follow the same rule. If we return to arbitration case, if we allow the party to arbitrate the dispute on patentability issue, that means sometimes maybe a patent, if you go through a judicial litigation, a court may invalidate this kind of patent, right? But if you don't, you just go through an arbitration procedure. Maybe the arbitration committee, the arbitral panel will probably affirm the validity of this kind of patent. So the public loses a chance, right, to invalidate this kind of patent. So that's follow the same logic, like in the court, in the Beckman case, the court say we are in accord with the district court view that such question of patent validity are inappropriate for arbitration proceedings. So they want to go through the the litigation rather than arbitration. That's the judicial practice in 1970s. But as we know, in 1985, the U.S. have a legislation. They abolished this kind of principle, this kind of practice, and started to allow the party to arbitrate the patent validity issue. That's the U.S. practice. I use these two cases, just want to show you that's really a serious public interest concern relating to the arbitrability of patent validity issue. So that's the theory. Now why in Hong Kong they choose to ignore this kind of public interest concern, right? Open the validity issue to be arbitrable. I guess the Hong Kong may have different interests. They don't have a manufacturing center, and they have a Hong Kong has a relatively small market for patent owners. And also, I guess the arbitration is a very important business for Hong Kong, right? It's as an important arbitration venue. So they have a different public interest. So they don't worry about the public interest in having an invalid patent. But in mainland China have a different policy. So my third issue is whether China in the future will change its attitude. Personally, I think probably it would be very difficult for China to change its attitude. Here I explain why. The first one, China have a very large manufacturing industry. I have participated in some discussion with them. They oppose this kind of reform because they probably believe the foreign patent owners, especially SCP owners, may force them to accept this kind of arbitration clause, and then this arbitration, this kind of arbitral award may probably, most of the time, may pro this kind of patent owner. So they are worried about this kind of problems. He lobby against for a legislative reform. The first one is China has a manufacturing industry, which probably will prevent the legislator from doing this kind of reform. The second one is patent office attitude. As we know, China have a dual track system. If you have in a patent litigation case, you want to challenge the validity of the patent, you simply cannot raise patent validity as a defense in a infringement cases. You need to file a case before the patent office first, right, to challenge the validity through an administrative procedure. So the patent office has this kind of monopoly over the determining the validity of the patent. That's the practice. In the past 2 or 3 years, there's a huge controversy over whether China would reform this kind of dual track system. For example, whether we should allow a court to review a validity defense directly in a patent infringement litigation. Supreme Court are pro this kind of idea. They make some kind of proposal to the MPC and wish the MPC to reform the law, allow the patent validity defense directly in a litigation. But this kind of proposal has been make the patent office very angry. I think he organized probably 5 to or even more authors to write articles to be critical of the Supreme Court proposal. So later on, the Supreme Court probably withdraw this kind of proposal. I just want to use this kind of competition between the patent office and the Supreme Court to show maybe the tendency in the future. I guess if we want to reform the arbitration law, make this kind of dispute arbitrable, and this kind of arbitration probably will become a threat to the patent office monopoly over the patent validity issues. So probably the patent office in the future will oppose any kind of the reform on this. That's my personal case. The third one, because when the agency or the manufacturing industry do this kind of lobby, they have this kind of real this kind of public policy justification, as I just mentioned at the very beginning, right? So if we really have a concern of public interests, and also maybe the Supreme Court also have some concern about the judicial sovereignty, it could probably become a barrier to this kind of reform in the future. So that's why I believe in the coming future, it's unlikely for China to abolish this kind of policy. Now I will very briefly talk about my personal observation. I believe that China's real interests probably is not to keep this kind of issue inalterable. Instead, I think that the Chinese real interest is consistent with this kind of arbitration. The first one, as we know, the arbitration could reduce the litigation cost for the parties, right? It's good for the parties. The second one, because the private parties have some kind of problem in trust foreign countries, this kind of judicial system. I think the United States have faced the same problem in 1980s. That's why the US later on removed this kind of ban on arbitration. So in China have the same concern. If we could help the private parties to reduce this kind of transaction cost, is also in Chinese long-term interest. The third one, if we really have some kind of public interest concern, I think that we could borrow the experience from the United States or other country to reduce this kind of negative impact to an acceptable extent. For example, we could require the party report their award to the patent office, right? If the you made this kind of decision and in this kind of decision, you invalidated a patent, and then we publicize this kind of decision. It could help the third parties, right? If they really have incentive to invalidate the same patent in the future through the administrative procedure, they could do so, right? So this kind of publication of the arbitral award could help to reduce the negative impact. And then if you still have concern, you could keep this kind of rule working, right? If necessary, we should allow a court to set aside an arbitral award in the name of the public interest, something like that. So I think negative impact on public interests could be reduced to a acceptable level. The third one about the last one about the government authority, I have already mentioned. The harm is very limited, where we simply say even arbitral award invalidate a patent is still only binding the parties. For the third party, the patent is still valid under the Chinese law. So the harm to the authority is very limited one. And the last argument against the current practice actually is pretty easy to circumvent this kind of ban. So if it is very easy to circumvent, why not just allow the party to do this kind of arbitration?
Okay, Professor Cui, can we leave this question to the Q&A?
Okay, no problem.
We need to move on.
Okay, sorry.
Thank you very much.
Just over here. Thank you.
Yeah, thank you very much, and I definitely ask that question. Our second speaker will be Mr. Thomas Tang, from Deputy Director of the Hong Kong HKSAR Intellectual Property Department, and he's going to talk about Hong Kong as the IP Trading Center in the Greater Bay Area.
Good morning to all. Thank you very much, Professor Lee, for your introduction. Well, first of all, I would like to thank the Faculty of Law of the University of Hong Kong for the invitation. It's really a pleasure to have the opportunity to share with you the latest initiative of the Hong Kong government in developing Hong Kong as a regional IP trading center. My presentation, I'm going to walk you through three topics. Well, first of all, it's about the government policy initiative on IP trading. That is a little bit about the historical background. And second is one of the major driving instruments is the outline of the 14-year, 5-year plan for the national economic and social development and the long-range objectives through the year 2035. This is, in short, known as the 14th 5-year plan of the Central People's Government. And the third area which I would like to walk you through is the specific policy measures under the 2022 policy address, which the Chief Executive has delivered in October before the Legislative Council. A little bit history about the policy initiative of IP trading. Well, the policy was driven back to 2013, so nearly 10 years ago, when the then administration decided to set up a working group on IP trading. Now, the working group basically contains members from various industries. Members actually came from, for example, the legal industry, legal practitioners. Some of the members are from various industry sectors, as well as we do have academia in that working group. And after holding various discussions, as well as meetings, as well as exchanges with various stakeholders, the working group published a report on IP trading. Basically, the report contained strategic recommendations as to how Hong Kong should promote itself as an IP trading hub. The reports, well, in short, the reports identified altogether 4 strategic areas which the working group recommended the Hong Kong SAR government should consider and should implement appropriate measures to advance the objectives of these areas. Now, the first one would be we need to enhance the IP protection regime in Hong Kong, SAR. And the second one would be we need to think about measures as to how to support IP creation as well as IP exploitation. The third area would be how we should foster the IP intermediary services and manpower capacity. Whereas the IP intermediary services that relates to industry sectors as well as professions relating to facilitating the conduct of IP transactions in the market or in the commercial world. Well, notably that will include the IP practitioners as well as, for example, the accountants, as well as various IP owners, because they are the creators of IP rights, as well as in the industrial sectors, because they are the one who would be one of the important chain in the ecosystem to exploit the IP rights as well as to commercialize the IP rights from ideas, turning ideas into actual products for commercialization. And the fourth one would be we need to devise appropriate measures to pursue promotion, education, internal collaboration. That would mean that we need to raise awareness amongst the publics as well as among the stakeholders as to, for example, what is actually IP. And we need to appreciate them that IP is a very important asset which carries values, and they should take appropriate steps not only to protect their own intellectual properties, but also they should know the appropriate strategies to manage those intellectual properties, as well as to think how they can exploit and commercialize their intellectual properties in order to maximize the economic values of the assets. Recently, actually, in the March 2021, last year, the Central People's Government promulgated the 14th 5-year plan. And in Chapter 61 of the 14th 5-year plan, the Central People's Government gave its first time national support for the Hong Kong SAR to develop itself as a regional IP trading center. So we have the Central People's Government support to the Hong Kong SAR government to advance further policies in order to promote Hong Kong, to position ourselves as a regional IP trading center, and also to implement appropriate measures and strategies to achieve our goal. Now, I would like to walk members of the audience through the specific policies measures under the recent 2022 policy address delivered by the Chief Executive in October. Well, basically, since 2015, after the release of the report by the working group on IP trading, the government has since then implemented various multi-pronged measures and as well as diversified measures to champion Hong Kong as a regional IP trading center. And also in view of the boost given by the Central People's Government under the 14th five-year plan, the Chief Executive in his first policy address identified three major strategies or approaches in order to help Hong Kong to further develop itself as a regional IP trading center. Well, basically, the approaches more or less mirror the strategic recommendations given by the working group on IP trading. The first one would be, it is always the one of the important as well as the determined measures of the government to promote IP trading is to continue to enhance our IP protection regime. The second one would be we would take appropriate measures to further strengthen capacity building amongst the stakeholders, meaning to enhance their knowledge, their professional knowledge in terms of protection, management, and commercialization of intellectual property as a valuable, intangible assets. And the third one, we would also strengthen the external promotion and education, because IP is to be an IP trading hub, we must have an IP ecosystem. The government is part of it, and we do acknowledge and we do treasure. We have partners in the private sector as well as in, for example, the tertiary institutions, universities, research centers. They are also part of our very important stakeholders. We need to collaborate with them so that we can work together to advance our goal. For enhancement of IP regime, the IP regime basically protects various kinds of IP rights. The first one would be the trademark regimes, where obviously the trademark regimes seeks to protect brands, it seeks to protect trade origins, trademarks, and it is a registrable rights in Hong Kong. Well, we will take forward the appropriate steps to implement the international registration system under the protocol relating to Madrid Agreement concerning the international registration of marks. Well, that is actually an international registration system facilitating trademark owners to apply trademark protections in multiple jurisdictions. Under the Madrid Protocol, the trademark owners can file a single applications designating various jurisdictions to apply for trademark protections instead of filing individual trademarks application in the relevant domestic jurisdiction. So that is an international registration system helping trademark owners to save time and cost in acquiring trademark protections in multiple jurisdictions. Now, the government has passed the Trademarks Amendment Ordinance back in 2020 and has been taking various steps in order to implement the international registration system under the Madrid Protocol. And one of the targets given in the policy address is we have to introduce a subsidiary legislation into the Legislative Council next year. And that subsidiary legislation would basically contains the relevant filing requirements as well as the procedures for applying for seeking trademark protections in Hong Kong through the Madrid Protocol. And apart from the introduction of the relevant subsidiary legislation, the Intellectual Property Department is also taking various critical steps in order to have the system in place. For example, we are updating our IT system. We also need to enhance our work examination manuals, as well as we need to conduct promotions and publicities among the stakeholders so that they are aware of the advantages under the Madrid Protocol. Now, the second very important IP regime is the copyright regime. As you know, copyright protects the expression of ideas, known as the copyright works. For example, books, movies, cable programs, television programs, sound recording, they also fall under the copyright protections. And the government, in order to strengthen the copyright protection in the digital world, the government introduced a bill, the Copyright Amendment Bill 2022, in June before the Legislative Council. And one of the mission or one of the targets which the government wished to achieve is prescribed to assist the Legislative Council to pass the amendment bill so that the legislative proposals for protecting copyrights works in the digital environment can be enhanced and strengthened. And I'm pleased to update you that the Bills Committee of the Legislative Council has already completed scrutiny of the bill, and it is expected that the bill, subject to various procedures and formalities before the Legislative Council, the bill may be ready for resumption of the second reading debate in early December. And we are aware that the amendment bill may not be able to address each and every new copyright issues. For example, Offen's work, for example, whether the copyright protection term should be extended, for example, whether Hong Kong should introduce a registration system for copyright work. So we are aware of the importance that the review of our copyright system needs to be ongoing, and we need to maintain our momentum in this area. So the Chief Executive, one of the very important measures is that we need to embark a new round of copyright review upon bringing the amendment ordinance into the operation, which hopefully the amendment ordinance would be implemented or would come into force sometime next year. Now, patents regime, another very important IP regime for protecting innovation, for protecting invention, for protecting creativities based on technologies. Hong Kong implemented our own original blind patent system back in December 2019. The beauty of the system is that the system enabled direct filing of standard patent applications in Hong Kong without actually requiring the patent applicants to file a corresponding patent application in various designated patent offices, which had been operating under the registration system back in 1997. One of the important objectives is we need to enhance the substantive examination capacity, because under the re-registration system, we only conduct formality examination. We don't actually need to conduct substantive examination to determine the patentability of the inventions. And upon introducing the original blind patent system, we need to conduct substantive examination. And because of the need to enlist technical expertise in this area, we have engaged the China Patent Office to provide us expertise to conduct substantive examination. But we need to work on our own. So we would enhance our substantive examination capacity by gradually increase the manpower of the patent registry to conduct substantive examination. Hopefully by 2013, we would be able to conduct substantive examination with our own institutional autonomy. And the other measures is because patent protection is territorial, which means that if you apply for patent protection in mainland, that protection won't be automatically extended to Hong Kong. So basically, you have to apply for patent protection in Hong Kong as our government as well. So this is territorial concept. But in order to assist the Hong Kong applicant to apply for patent protections in the mainland, we are working with the Chinese Patent Office, or known as the CNIPA, to roll a pilot project to work out a scheme to enable Hong Kong applicants to enjoy prioritized examination of their qualified patent application in Mainland. Well, because of the time, I would walk through the rest of my PowerPoints, and I'm happy to talk more during the panel discussions. Well, another area is the registered design regime. The regime, basically, Hong Kong localized our own regime back in 1997, but since 1997, there has not been a major review of that of the registered designs regime. So the government are aware the importance of this area, because registered design basically protect industrial goods, the designs of industrial goods, and it would enhance the commercial values of the industrial goods for enhancing their commercialization. So the target is to launch a thorough and comprehensive review of the regime in 2014, and hopefully we can conduct a public consultation in 2025. Now, for manpower capacity building, IPD has already implemented or has already launched an IP manager training program. And under the program, we provided training to these small and medium enterprises, known as the SME, because they need resources to update their knowledge in the areas of IP. And the target is we will continue to provide training for these personnel within this term of government. And we will also collaborate with the Department of Justice to continue promoting IP mediation and arbitration services. That would be very important, or an alternative means for IP owners to resolve disputes other than through the formal court proceedings. And we would continue working with the Law Society of Hong Kong to strengthen our cooperation to enhance the free IP consultation services that we offer one-to-one free consultations to SME to answer their questions about their IP rights, as well as to give them professional advice as to how to resolve disputes. For promotion, we appreciate that it's very important to appreciate the youngsters, the students, as to the importance of IP. So we need to promote IP literacy. So we're going to reach out 100,000 students within this term of government in order to enhance their awareness, and also, most importantly, because they are the pillars of our future, youngsters, to encourage them to actively explore creativity as well as innovate. And the other thing we need to do is to liaise with the Mainland Authority as well as international organization to promote our positions and our role as a regional IP trading center. And third, a very important partner of IPD is the Hong Kong Trade Development Council. We are going to continue working with the Trade Development Council to promote IP trading and professional services through various means, for example, trade missions, seminars, publicity program. And we are going to have one of the flagship IP conference event in December, known as the Business of Asia IP Forum, BIP Asia. And that will normally be held in December each year, in order to give a platform for various experts in IP from the local as well as from the overseas jurisdiction to share their ideas about IP and to invite participations amongst various stakeholders to update the latest position in the market and to update the latest changes in relation to, for example, law and regulations concerning IP. Well, I'm sorry because of the time, so I can only manage to give you an overview as to the government's policy initiative in order to promote Hong Kong as a regional IP trading hub in order to drive more economic growth. Thank you very much for listening.
Okay, thank you very much, Mr. Zhang. Our third speaker will be Dr. Albert Wycliffe Chang. and who is the founder and the director of the U.S.-China Intellectual Property Institute, and also the partner of the law offices of Albert Chen. His topic.
Thank you very much for Professor Lee. I love to see the dean actually still sitting here for all the IP. I would like to take a poll first. How many of you actually take some introduction pen class? Nobody. Okay, great. So when I come to a meeting like this, when all the speakers are running over time, it really tells you that because the issues are so urgent, I promise you that I'm going to finish my speech in 7 minutes. If I'm over the 7 minutes, you can expect. So it's very hard if you don't really have a pen concept. And pen is really one of the most powerful weapons you can have in this intangible world. Because you have the exclusive right, and it's very powerful. And as our Zhang Qu, spending all the time, we have a lot of resources. So you should go to HKSAR website and read about it. I'm very lucky. I'm a patent attorney. I love all the high tech and everything. Here is a little bit like overall, we'll talk about all this region. 9+2, right? So, but we have 3 different systems. So it's a little bit chaotic for you. You have not really taken any patent classes, right? But it's okay. I think IPD, Zheng Chu, 3, right? I saw the 3 consultations. We'll go through everything. So all the 3 districts, they actually have 3 totally different like jurisdictions. And as I probably talk about all these harmonization, everything. So it's going to make you drowsy. But don't be afraid. Just before you go, Macau, look at the number. Is it important? Maybe, maybe not. Whole year you have 1,000. Who cares? Us, right? So Zhang Chu is we better. We are better. Look at all the numbers. Here's the original patent as Zhang Chu is talking about, right? Thomas was talking about, right? We start the process. It's complicated. We first have to train the trainers, right? What are the examiners? We have to rely on 背靠law. So we're relying a lot in China and everything to do many things. But still, 20,000. Hey, here comes the baby. Look at China. Look at China. Look at the numbers, right? Fascinating numbers. Right? So IP, when we talk about IP, when we talk about intangible asset, we have to really think, right? This is the real player, right? The whole world. 每一天习主席都说，对不对? We have 1.4 billion people. We have 1.4 markets and the intangible asset. So 3 systems complicated, right? When you talk about the rights, we have to talk about claims. Claims are defining your rights. And so when you have 3 different jurisdictions, you would have 3 different sets of claims. So which is which, right? So again, there's many terminology. Patent prosecution highway, meaning you can go in very fast. Thomas just talked about it. All the Hong Kong people try very hard to create pilot programs so that we go to China and do prioritization examination, so we don't have to follow the regular queue. So we would basically team down so that you can jumpstart all your rights, right? So again, learn from that, right? So we, Hong Kong, are very innovative. A lot of people don't know that we are so innovative in terms of our protection. We create this wonderful system. It's called a short-term patent, which practically have many, many features. You don't have a lot of money, you don't have a lot of resources, do a short-term patent, please, right? However, very unfortunately, well, probably there's no number here, but the rough number is that Thomas probably can tell us, right? 700, 800 last year, not even 1,000. So I always encourage all the people, your petitioner. Very interestingly, when I'm setting up my practice in IP in Hong Kong, being a US practitioner, I actually didn't know that all these IP practices, not all practice, even though we taught in the law school. So with all this, I think that if you're open-minded, you want to enter the field, this is a wonderful place, right? Hong Kong short patent. Finally, this is a very important slide, right? Go back to China. Go back there, and then they have all the IP5, everything is very modernized over in China. So still, relying on this CNIPA, the Chinese intellectual property agents, it will really help you. So my overall kind of strategy is that you can start in Hong Kong, do a short pattern, and then go to China. Now, of course, very unfortunately, I'm American, right? I believe in America and everything. So you can do the US provisional as well, right? So if you're familiar with that. But this will be final substantive slides, right? So you can start with Hong Kong short pattern, going through the so-called Paris Convention type of policy claim, then go down in this particular path, and then you can broaden it and go to all these 3 jurisdictions. Did I meet the 7 minutes? Maybe. Okay. So I don't want to rush everybody. So if everybody wants to talk with me during lunchtime, I would love to talk with you because I know that there's 2 more distinguished speakers. I will end here.
Thank you very much. Thank Albert for saving some time for us. Our next speaker will be Professor Jian Li, who is a professor of law of Chinese University of Hong Kong, and he is also the director of the Center for Legal Innovation and Digital Society of CUHK. He's going to talk about copyright protection for AI-generated works in GBA. Welcome, Professor Li.
Thank you, Yahong. Hello, everyone here. Hello, my friend for being in Beijing. Yahong reminded me many times that I need to be brief. So probably I could not finish within 7 minutes, but I will try to be fast because I understand that we have a full panel of 5 presentations, and I am actually presenting between you and lunch. The topic today is about copyright protection for AI-generated content. So as we all know, so AI can do a lot of these nowadays, including creation. And in the Greater Bay Area, I would say Hong Kong and Shenzhen in particular, that we put a lot of resources in AI development. So one of the major issues is that AI-generated works, are they copyrightable or not? My slides?
Yeah.
All right. If you take a more comparative perspective, you will see in the majority of the jurisdictions, AI-generated works are actually not copyrightable in US, in Europe. But very interesting to see that here in Hong Kong and in mainland China, so we have a case in Shenzhen, which actually recognize the copyrightability of AI-generated works. So I will just introduce this very, very quickly. So in the United States, so the US Copyright Office made it very clear, if a work is not created by human beings, you are not going to get any copyright protection. So which is that you don't get any copyright protection for AI-generated works. And in EU, so according to case law as well as the EU directive, so they actually reached the same conclusion, which is that AI-generated work is not copyrightable because you fail to see the so-called human creativity or originality in the creation of the work. But that is actually not like a case everywhere. So the case of Hong Kong or the case of Shenzhen, so we see something very different. So here in Hong Kong, this is our copyright law. So we have a very special type of a copyright work called computer-generated works. So that is actually a transplant from UK. So in UK, they have the CPDA 1988, so which recognized the copyrightability of the so-called computer-generated work. And most of the practitioners believe this clause can be applied to the so-called AI-generated work. And we have very similar provisions in other Commonwealth jurisdictions as well, which includes Ireland, New Zealand, India, and of course, that comes from UK. In UK, if you recognize the copyrightability of the AI-generated work, who is exactly the author? So according to the law, that is the person who makes necessary arrangement to the creation. And then here's the problem: who is the person that makes necessary arrangement? Is that AI programmer or the AI user? So in UK, we have a case, but that is not for AI-generated work. That is actually the screenplay during a video game. And then the court made that very clear that it is not the user or the player. It is actually the programmer that make necessary arrangement. So in other words, if you apply take to AI generated work, so who write that AI algorithm would be the author of AI generated work, who can own copyright over that AI generated work. And in Shenzhen, so we have a very interesting case, which was decided in the end of 2019, right before the outbreak of the COVID. And in that case, so Tencent developed a very, very interesting AI application, which is the so-called Dream Writer. So Dream Writer can write articles automatically, basically just analysis of the stock market. So you can basically set this requirement of what stock market, what period of time that you would like to do the analysis, and they can also provide prediction. And in that case, because the article is generated by AI, so someone just took that without permission of Tencent, and that defendant basically argued this is not copyrightable because in China, so the standard of originality mostly translated from United States, and in US this is not copyrightable, so this should not be copyrightable either in China. And then that was the argument made by the defendant. And then Tencent was trying to prove human involvement and originality in the production of that AI-generated content. So basically, Tencent tried to categorize the process of the production into these 4 stages. And in each stage, Tencent tried to argue, this is not decided by AI. So we actually decide a rule, and AI just follow our rule to do that. So this is where we can find a human creation. So that is the litigation strategy by Tencent. And eventually, so that actually surprised many people at that time. So which is that the court bought the argument of Tencent and recognized the copyrightability of this AI-generated content by Dream Writer, and which of course take a very different approach, different from the previous originality approach that mostly translates from the US law. And basically, the idea is somehow relevant to this concept of a compilation, because Tencent successfully argue there is original selection and arrangement of some raw material, and there is where we can find human creativity. And then many people argue, so the Greater Bay Area, in particular, Hong Kong and Shenzhen are ready to embrace AI in terms of AI-generated content, because this is copyrightable only here in Bay Area, but not in other parts of the world. So my question is that, are we really ready for that just because that we can provide protection for AI-generated content? So I don't think that is that simple for a number of reasons. Number one, IP is about incentive. So if you don't need that incentive in our society, so the monopoly provided by AI just brings social cost. So that might not be just by this kind of social cost or monopoly. So if you take a look at the investment in AI technology around the world, so most of the countries, they don't provide that protection, but the investment still is going up in recent years. So that might be one of the reasons that you don't need copyright protection at all. Number two, so if we have that AI work, so this is the process, we have programmers, they write AI algorithm, and then these programmers can, of course, this AI software is so intelligent, so smart, and they can generate something like the poems, the article, like the article created by a Dream Writer. So what about IP? So programmers can, of course, go copyright, sometimes patent over this computer program. There is already one set of IP from that creation. And if you give programmer another IP over AI-generated content, so that it's actually another IP. So you can get 2 types of IP from one single creation. And then the policy issue here is that are we provide just too much reward for a creator? Because we actually are not going to give like too much reward. That will be bad for the society, too much social cost. So we want to have the optimal level of reward. And then in this debate, sometimes I just think that in the history of copyright law, we always repeatedly see this kind of a debate. So this is a decision by the Supreme Court in the United States in the 19th century, so which was about whether photos can be copyrightable. This is a photo of Oscar Wilde, And of course, this is a common thing for all copyright practitioners that photos, of course, are copyrightable. But at that time, so the argument made by most of the artists at that time was that this is, of course, not copyrightable. You just use the machine, you press the button. There is no human creativity at all. But the Supreme Court in that case explained that, it's actually still some creativity. You need to pay attention to the angle, the shadow, the object. This is where we find human creativity. And we see very similar debate in copyrightability of AI-generated content. And then I think everyone know that the technology and education is changing very fast. In these days, our kids are learning coding in school. So probably the way that they use AI to create would be very different from us. And the other thing that we need to think about is there are some doctrinal issues. So if we say that the programmer is the owner of the AI-generated content, so is that correct? So that might be much more complicated than the British case Nova, because in the AI-generated word process, there are a lot of stakeholders. They all play very important roles, such as investors, not only programmers, machine operators, trainers, or the so-called data providers. So among all these stakeholders, so who is the person that can own copyright? So it's not that easy to determine, and sometimes AI may collaborate with human beings as well. And if that happens, so do you mean that the programmer and the person who will collaborate with that AI should be co-authors? So that is still disputable, and this is actually happening here. Sony has this AI who can collaborate with the human composers. And that will probably completely change our understanding of the so-called joint authorship. And not only that, a lot of these AI algorithms, so they are open source projects, so which means that they are contributed by programmers, contributors around the world. So there might be hundreds of thousands authors of a single piece of software. So are they all authors? If they are all authors, how could we enforce copyright? And this is actually happening. A lot of the Google AI projects are open sourced. And then other than that, a more complicated issue is that AI, of course, can generate software. So what about if AI generates software and that software generates another software and the software just keeps generating different software? So you have like different generations of the AI generated works. And that is also happening. Google has this auto ML project, so which develop like different generations of projects. This is endless production. And can you argue, or you feel comfortable that the person who can develop this kind of software can just endlessly own all these different generation of different AI generated works? So these are all unsolved issues. So when we say that we are ready to embrace AI in our copyright law in Greater Bay Area, I do think we are actually not ready, because there are a lot of complicated questions that we need to think about. Right, thank you.
Thank you. Thank you, Jian. Thank you for saving some time as well. Our last speaker will be the Dr. Haifeng Huang, who is a partner of Jones Days in charge of intellectual property practice in the Greater Bay Area. He's going to speak at territoriality, extraterritoriality application, and the harmonization of IP from a GBA perspective. He's going to wrap up about everything we are going to talk about, and with the focus on the trademark.
Thank you, Yahong. I'm glad to be here. I saw some students attending this conference as well. Good to see you guys. Your attendance has been well recognized by Yahong and myself. The topic about the extraterritorial application, which is a little sensitive in the backdrop of the long-arm jurisdiction from the United States, and also some recent anti-foreign sanction law from China side. But the good news from the IP perspective is this topic in this area is much less sensitive, more technical, and much more fascinating for this sort of discussion from the IP perspective. Patents, trademarks, copyrights, and also to a certain extent trade secrets they're all called under this category of intellectual property. But if you look at the history, none of them has been treated as property or has never been universally recognized to be protected as a form of property. In most cases, all this right, patents, trademarks, copyrights, to the certain extent, trade secret as well, they will be considered as the local rights. They're granted by the government of each different jurisdictions. And then, so that's why all those rights are limited to the jurisdiction where those rights have been granted, and they're only valid within that jurisdiction. And also the law enforcement authorities, courts or other agencies, they can only have power to enforce the local rights, have no jurisdiction to look at the rights of foreign countries. And also in the same fashion, they are only able to address the infringement that are committed within the local jurisdiction. They're not allowed to look at the infringement that are committed outside of the jurisdiction. So this is the typical territoriality of intellectual property. Traditionally, this has been very well accepted theory in most jurisdictions. And the law theory in China, I think this is very popular in China as well. If you talk to certain judges, talk to the scholars or professors in China, they all recognize IP has to be territorial. But nowadays, there is no longer such absolute territoriality in the IP area as well. With the globalization and also digitalization, and to the certain extent, regionalization as well. So you see an increasing flow of goods and service across the borders. So that's why you have seen a lot of efforts probably in the past 50, 80 or 100 years. People try to facilitate the procurement and protection of intellectual property rights across the borders. So that's why you see the Paris Convention, you see the Berne Convention, and also you see TRIPS as well. For example, one of the articles under the TRIPS agreement, was saying, even for a trademark, which is not registered in a member country, but the red trademark is, has been well known or famous in another member country, and then that trademark unregistered in your own country, it needs to be protected to a certain extent as well, but may not be as protected as a registered trademark right, but should be protected to certain forms. So that is the form of extraterritorial recognition of trademark rights through TRIPS agreement. And I think Europe Union has done a lot of effort. They have established EPO, a unified patent office, to look at all these patent prosecution issues, the process within the union. And also, I think the last 2 or 3 years, they have established this UPC, Unitary Patent Court. So this court can also look at all this patent dispute within the member states of the European Union. So that's why you see a lot of extraterritorial extensions or discussions among different countries and among different jurisdictions. So nowadays, when we talk about this territorial of IP, you will see absolute territoriality, which is related to registration and also validity and also the ownership of existing IP rights in each different jurisdiction. But people will also recognize the territoriality must be relative for certain other aspects of IP issues, such as infringement and also contract as well. In terms of infringement, a lot of jurisdictions, particularly US, has made a number of different attempts to try to see what type of infringement cases can be adjudicated by the local court, but those dispute may have certain international elements. For example, in the trademark areas, there are some cases. I think this morning I also saw news in Supreme Court from the United States has accepted a case, for a retrial review. They look at, if both parties are within the United States, but the other party committed trademark infringement in a foreign country, whether the foreign sales of those infringement goods can be adjudicated, domestically by a U.S. district court, and that's the issue to be answered by the Supreme Court. And also in the patent litigation areas, and you will see, some inbound or outbound discussions. I think the cases have been very clear to say, if you make certain components within the United States and then sell the components to a foreign country, but piece all those components together, that will be infringement of certain US patents. So even you don't put them together in the United States, but if you make those components, with the specific intention of putting them together in a foreign country, and then the US court will have jurisdiction to look at that dispute as well. And also, from the outbound perspective, if you practice certain patented process in a foreign country, and that process has been patented in the United States, and for that product to be imported into the United States, the US court has also recognized it has the power to look at that case as well. And of course, in the contract scenarios, we have similar issues or discussions as well. So coming back to China and Hong Kong, mainland China and Hong Kong, in the past, all these years, you probably have heard a lot of cases involving the disputes that cross the border between Hong Kong and mainland China. A lot of those cases happen to be in the trademark on-site competition or passing off areas. One very typical scenario is you have some mainland Chinese parties who come to Hong Kong and set up a shadow company. That shadow company may use international brand, maybe Puma, maybe all this different international brands. And then they may come back to mainland China, and then they will use that brand because they say, I have a registered company from Hong Kong. And then they will say, I get a license from this Hong Kong company who allow me to use maybe say, for example, Apple or iPhone in China. And also they will have that Hong Kong setup company to file applications in China to get certain trademark registrations. If those trademarks have not been fully registered or in different classes. So that creates a lot of disputes about whether the Chinese court can take any actions against the setup and operation of those companies which are registered in Hong Kong, or if you go ahead to bring the lawsuit from the China side, and then if you bring the lawsuit from the Hong Kong side, then the question would be, whether the Hong Kong court can issue an injunction against those Hong Kong local companies, for the activities they may be doing, on the China side. They say they file those trademark registrations, they do all this promotion and all this marketing and do this licensing, in all this on the Chinese side. So that issue has been a real issue for the past years, and also we were likely to see this issue to be more prominent in the future. So that's why that push, both sides, to really consider how, with the integration of Hong Kong into the greater Bay Area, is there anything that should be done from both sides, from Chinese side and also from Hong Kong side, to really look at this territorial principle under the intellectual property law in both jurisdictions. I think one of those efforts was this judicial arrangement between Hong Kong and China on the mutual recognition and enforcement of those judgments in civil and commercial matters. This is a very significant judicial arrangement because it goes beyond even the Hague Convention. Hague Convention does not cover any IT-related issues. The Hague Convention specifically exclude all this IT coverage. But this judicial arrangement specifically covers certain IP matters. It covers copyright infringement, trademark infringement, and also trade secret infringement as well. And for trade secret infringement, this judicial arrangement even allow the injunction orders to be issued from either jurisdiction to be recognized and enforced in the other jurisdiction. Of course, it has excluded some other matters like validity or existence or ownership of IP. And also, for some reasons I don't understand, this arrangement has also excluded the disputes of those patent infringement. But of course, those standard essential patent, friend rent determination dispute has been explicitly excluded as well. And also injunction for some non-trade secret cases, that has been excluded as well. I think this judicial arrangement was discussed back in 2018 and 2019. At that point, China has not really looked at, whether it should play a more proactive role in deciding those global rates for the standard essential patent. Probably that's the reason this arrangement has included the cases involving the standard essential patent and also frame rate determination. But I think for the next step, you probably should look at whether it should cover those patent infringement cases as well. I want you to look at this article because one of the conditions for the judgment to be recognized and also enforced for the other jurisdiction across the border, the parties needs to show the original court handling that case has the jurisdiction. If they say you don't have any jurisdiction to handle the case, then even if you issue a decision, that decision won't be enforced across the border in the other jurisdictions. So in the IP areas, I think this jurisdictional requirement can be looked at from the two perspectives. One is they say this infringement needs to be happening within your jurisdiction, so you have right to decide on that case. The other aspect is you have to show the local right, local interest, IP right, IP interest that require the protection from the local courts. I think naturally then the question will come up. Say if you have two parties in Hong Kong, two Hong Kong local parties, and then one of the parties committed certain infringement acts in mainland China, and then Hong Kong court will have natural jurisdiction of power to decide on the disputes on the two Hong Kong parties, right? And then the issue is whether Hong Kong court have power to cover or address those infringement being committed by the defendant on the mainland China side. If they do that, and then I think under Hong Kong law, Hong Kong court have absolute power to decide on those disputes. But that judgment can be enforced, through this judicial arrangement in mainland China. Then that will be a question mark. So to a certain extent, people need to look at the arrangement, through this territorial and extraterritorial perspectives. What else to make sure this sort of arrangement can be more effective to resolve all these disputes, across the border, given the future integration of Hong Kong into these larger areas. Of course, there are some remaining questions as well. For example, if you have panel proceedings in mainland China and also Hong Kong, if one party bring an offensive action in Hong Kong and the other party goes back to China to bring a declaration, judgment action to say there's no infringement from the Chinese court. Certainly, if both courts proceed, you will see some conflict of the decisions from both jurisdictions. And then the issue will come up as to, whether one court should stay the proceedings because of, the forum is not so convenient. And also if both, goes forward and then we talk about injunction from either side, because they have each court from either side have the power to issue injunction against that party residing in that jurisdiction, right? And that injunction may have the cross-border effect. In that case, whether one court may say, I don't want the other court to move faster, than my court, and then I would like to consider anti-suit injunction. This has been discussed in a lot of those patent cases involving parties from US, from other places. But whether this type of disputes may come up involving the parties across the border here, within the mainland China and Hong Kong, that can be another issue. So the comity and also respect of the judicial sovereignty for either side, those issues will be discussed in this type of context as well. So I will just stop here.
Thank you very much. Just on time. Yeah, great talks from all speakers. And I think, from their talk, we realized that the harmonization is very difficult with one country, two system, just like a driving on the right or on the left. How can we choose, or can we choose the middle one, right? And so we are going to have a Q&A. Perhaps I request from Dean, maybe 5 minutes more, depending on how many questions we are going to get, right? Because we have 5 speakers for our panel. Okay, so I promised Professor Cui, because I caught him up, I promised to ask him the question he's going to cover, but didn't have time to cover, the how to avoid the conflict between Hong Kong and mainland China in terms of arbitration award problem. Professor Cui, can you
Okay.
maybe take a
Okay, thank you for your question. I'm sorry for using more time than expected. As to how to avoid the conflict, I think I read several articles. Someone have made some useful proposals. One of them is that the parties in the agreement could say allow the arbitral panel in the future to adjust, for example, the patent, the license royalty, or other license terms, in considering the likelihood of the patentability issue. So this kind of term will allow arbitral panel to review whether the patent quality is good enough, right? If they believe the one party has presented enough evidence to show it's very likely this kind of patent in the future will be challenged or be invalid by Chinese patent office, and then the tribunal could adjust, I think, the amount of license fee or the other license term. If you have this kind of agreement, I guess this kind of arbitral award should be respect or honored by the Chinese court in the future. I think that's also a common practice, right? In the SCP license area, usually a license involve hundreds or thousands of patents, and it's pretty common for the foreign court to determine a global license rate for this kind of license. So if this kind of decision is could be honored by Chinese court, I guess the same decision from arbitral panel should have the same effect if they only consider the likelihood of invalidation rather than the validity issue directly. That's probably the most important strategy. Okay, thank you.
Thank you, Professor Cui. And I think I'll open to the floor. And I have a lot of questions, but I would like to invite the audience to hold the question. Okay, yes.
So my question is to Mr. Zhang. So it's nice to know that the Hong Kong government is now building this place a kind of transaction center, IP transaction center. Actually, I'm doing quite a lot of research on this area, and there are two. And your presentation actually focused a lot on establishing IP protections and also providing education and also consultant services. But there's two important issues from my observation that is very important and impede the transaction of IP. The first is the evaluation of IP asset, because establishing IP protection not necessarily automatically transferred into a kind of commercially valuable asset. So nowadays, we don't have a very good system regarding the presentation of the commercial relevancy of the assets. And also, we know that IP, especially patent, which covers technology is also is merely a part of the input of the innovation. And there's no a very good system to present the relevant complementary assets associated with that input. So I think so one of my questions is that is there any system that the government is consider that is creating certain kind of system to present the commercial relevancy of the IP asset to the company's business operation?
Well, thank you very much indeed for raising this question. I think the question really focused on IP valuation. I think you are talking about IP valuation.
Yes.
As to how to value a piece of assets, because we are talking about an intangible asset as opposed to a fixed property. Well, for a fixed property, valuation can be relatively easy because it always adopts a comparative approach. You compare similar properties to ascertain the values of an asset. For IP, the difficulty lies in the nature of the property, because the property is intangible in the first place. Well, actually, in response to this question, you recall I mentioned reports given by a working group on IP trading back in 2015. Well, actually, in that report, there is some discussions about topic as to IP valuation. And we are aware of the difficulties, and we are also aware, we also have regular exchanges with different stakeholders as to how property should be valued. And actually, we once worked with the professional body to see whether there is certain guidelines, I mean, in assisting the industry or assisting the corporate, assisting the IP owners as well as the users to evaluate a piece of property. Well, maybe I can, after this session, I can give you a link. There's actually, we have worked with, we have collaborated with professional bodies to try to lay down some basic guideline as to how to evaluate intangible property. Oh, I cannot say that, well, the guidelines are exhaustive, because as this, the concept of IP trading is not exclusive. I mean, in Hong Kong, Singapore is also promoting the city as an IP trading hub or IP commercialization hub. This is really not a really straightforward topic, and we need to work with stakeholders, particularly the accountants, the valuation industry, to try to come across a guideline that is universally recognized by different jurisdictions, for example. So probably I can give a link of that piece of guideline.
Thank you.
Okay,
Thank you.
any other question for other speakers? Okay, go ahead.
Oh, thank you. I have a question about the standardization patent license.
Sorry, can you speak?
Oh, sorry. Thank you for all the speeches, and I have a question about the patent licensing issues about the standardization patents. Actually, there's a global rate-setting trend in the different jurisdictions. Like a single jurisdiction can set a global rate for a SP patent, and there is also a trend of that anti-suit injunction among the US and China and also UK. So like in the Unreal Plant case and also Oppo case in China and Xiaomi case, like there's a like described by Professor Lee, that's a ping pong style Olympic games between that anti-suit injunctions and anti-suit injunctions. So will that licensing rate issues be an arbitrable issues, and also another side, a territorial issues mentioned by Haifeng Wang. So will Hong Kong be a balancing point for them to settle this dispute by arbitration? That's my question. Thank you.
Will you speak? Yeah.
Yeah, so I was surprised to be asked these questions because this is not the topic of my presentation, but you are right. I had a number of papers about FRAND and FPP license. So you are certainly right. We see the surge of the so-called anti-suit injunction in the context of SEP and FRAND in the past 2 years, especially in China. We are actually trying to figure out what was going on. So the approach that we used in that paper published in Michigan Technological Review is that we argue because the SEP is somehow relevant to national security, because you see all these 5G is very important infrastructure. So the technological competition between US and China also kind of like has the battlefield in that SEP. And going back to your question, so you are right. There are a lot of advantages of using arbitration to resolve the SEP issue. So in terms of efficiency, in terms of professional knowledge. So it's probably easier. But of course, there are still some suspicion about this proposal. So one of the major arguments mostly made by legal scholars, not practitioners, is that still, we have no idea what is the best approach to decide the so-called global rate or SEP rate. So if you use the court to resolve that issue because of the transparency, so it might be good for the so-called patent jurisprudence to develop. It's easier for people to understand, and then we can still scrutinize and subject that kind of a reasoning to debate. But for arbitration, of course, this is confidential. You have no idea how that is decided. So I think a main criticism against that arbitration approach is that probably at this stage, that might not be good to develop the right approach to find the so-called SEP rate. But of course, this is not my personal perspective. So, for Hong Kong to do that, I think probably just going back to Guobing's question, so why Hong Kong has this rule in arbitration ordinance? So I completely agree what Guobing just mentioned, but I think there are probably two major points that I can see here from Hong Kong. Number one, because Hong Kong has defined itself as an arbitration center. Strategically, it would be good for Hong Kong to expand the scope of arbitration. And we can also see that in the so-called Greater Bay Area Initiative, so which also define Hong Kong as a center for dispute resolution. This is number one. Number two that I can see about the role played by Hong Kong is that so as Guobing says, so Hong Kong does not have that manufacture industry. The other thing that I think that might be relevant, but Guobing didn't mention, was that so before 2019, Hong Kong did not have that substantive review for patent application. So that might be the reason that the government feel more comfortable that patent validity might be challenged in other proceedings.
I just want to add, anti-injunction, in most cases, will be considered as an evil, maybe a necessary evil, to fight back and try to retain your own jurisdiction on certain cases. But it does not resolve any disputes. It creates additional disputes, even disputes among the courts of different jurisdictions, create all this judicial race, and all this fighting among different courts or enforcement agencies among different jurisdictions, cause a lot of uncertainties among the parties being involved in those disputes. Right now in China, I think this anti-injunction has been limited to patent, essential patents in some maritime cases as well. But whether that can be extended to other areas of dispute, that will be a question to be watching in the future. I think coming back to this GBA perspective, as we discussed, we have three different jurisdictions, three different systems, and then in the IP context, there can be some tensions as well. In the trademark disputes, on-site competition passing off, certain extent, patent disputes as well. So when I look at all these issues, one possible scenario could be beside the arbitration, proposed, SEP dispute to be resolved through arbitration. A possible angle, just to think aloud is to look at the example being set up by European Union, like they have this unified court. So I think, within this GBA, Greater Bay Area, whether in the future, maybe a far future, whether, if we want to look at integration or harmonization, whether there is a possibility of, establishing a unified court within this region to look at certain subject matter. Those disputes can be filed through this unified court for certain cases involving certain features, and then courts can look at I think right now the Hong Kong court will look at the concept like double actionability, right? If you have a case that is actionable in Hong Kong but also actionable in other jurisdictions, and then the Hong Kong court can issue a global injunction, injunction that has an effect outside of the Hong Kong. So that sort of issue, will likely come up in the future, with Hong Kong being more important as the scientific or research hub in this area or region.
So anything from others?
I find it fascinating with that young man over there commenting on Hong Kong IPD, and then the issue here is about evaluation. Still, when we talk about SCP standard, whatever, all these things relating to money, right? So I think Hong Kong, we have a very unique position, and what we're good at, we're good at money. Right? So I think the law school should definitely really help to establish a more unified system. So when people would come to Hong Kong, they would know we not only have the law, but we also would know your value, right? So you come over here, we resolve all those issues, right? Back on your notion. And so I think it's fascinating, in particular with Paul Chan is keep talking about with all these virtual asset plus all these like financial tech that work together. Right? So I think it's fascinating, but it's all up to all the younger people.
Thank you very much. And
Well, I just want to supplement my early answer to that, to the question raised by that gentleman. Well, actually, you can go to our website, ip.gov.hk. There is a section known as trading IP. And under trading IP, there is a section known as evaluating IP. And you can find some useful information on that. ip.gov.hk. Thank you very much.
okay, thank you very much. I think we wrap up this panel. And I think from this the speech, we know that harmonization is very difficult, but harmonization doesn't equal to unification or unity. The harmonization will also embrace the diversity or uniqueness of each jurisdiction. And then we will probably focus on what are the strengths, advantage of each jurisdiction and put them together. And then figure out whether we can find something. Albert mentioned the synchronization of IT law, and I think maybe we can also think about some technical neutral just legislation on some very technical area like AI in the Greater Bay Area, and then we can also think about maybe EU's model for some directive. Which is not going to be enforced, but to have serve some guidance, right? So I think it's great the panel. Everyone contributed. I think it's a very exciting and a very interesting insights, and we can take forward to think about for future development in one country, two system. So yeah, let's give a round of applause to each of our speakers, and also thanks Professor Trey joining us remotely from Beijing.
Okay.
Thank you.